Swayam Prabha. Digital India. Educated India.
In an infringement suit, if a patentee becomes successful, he succeeds in an infringement suit, then he can obtain what is called a certificate of validity, and once a person gets a certificate of validity, that can be used against future infringers. So, a patentee succeeds in an infringement suit, asks the court to give a certificate of validity or the appellate board to give a certificate of validity. Once the board or the high court issues a certificate of validity, and if there is another infringer who is infringing, he can inform the next infringer or the second infringer to say that there has been an earlier proceeding and my patent has been upheld and I have a certificate of validity, stop from doing things. If the second infringer still continues, upon filing an infringement suit, the patentee will be entitled for costs from the second infringer, because he has already put the second infringer on notice and he has already told the second infringer that he has been through an earlier infringement proceedings, the court has upheld his patent and issued a certificate of validity. So, the effect of a certificate of validity is that it becomes easy for the patentee to claim costs against a future infringer. Section 113 deals with the certificate of validity. We had already mentioned that the certificate of validity is a certificate that the patentee can obtain after there has been a proceeding under section 104. There has been a proceeding and the patent was challenged, there was a revocation challenge on the patent, which in other words means the validity of the patent was challenged and the validity of the patent was upheld. The claim was found to be valid either by the appellate board or by the high court. The appellate board or the high court may certify that the validity of a claim was contested and in those proceedings it was upheld. So, this means it is a certificate that is issued after a challenge is made on the validity of a patent. Largely we refer to these proceedings as revocation proceedings. Revocation proceedings may happen either before the Intellectual Property Appellate Board or before the High Court. So, wherever revocation grounds have been raised against a patent and the patentee successfully defends them and the patent does not get revoked as a consequence of that, the patentee is entitled to get a certificate of validity saying that the claim was contested and it was upheld. So, this is the certificate of validity is pertaining to claims that were contested, claims that were claims against which there was an ground for revocation and the claims eventually survived the ground for revocation. So, which we refer to as claims that were upheld to be valid. Now, we had already mentioned the purpose of a certificate of validity is if there are any future proceedings where the validity is going to be contested arguably by another defendant, another party, then the patentee can put that person on notice to say that there has already been a proceeding and this patent has been upheld. So, if you pursue with this invalidity challenge, that the patentee will be entitled for an order of payment of his full costs. Subsection 2 refers to full costs. So, this certificate of validity allows the patentee to put a third party on notice who is interested in further challenging the patent and to claim full cost, the cost of proceedings, the cost that a patentee would incur in defending the validity challenge. So, this is a provision by which you can put the person on notice, and eventually when the patentee succeeds, he will be entitled to claim costs. Now, there are some details in this section which you can figure out. Subsection 3 says nothing contained in this section shall be construed as authorizing the courts or the appellate board hearing the appeal from decrees or orders in suits for infringement or petitions for revocation, as the case may be, to pass orders for costs on the scale referred to therein. Now, there can be an order on costs, but the order need not be an order for costs on the scales referred to therein. So, there is only an obligation for the court and the appellate board to award costs. You will find it here, where any such certificate has been granted, if any, if in any subsequent suit before the court for infringement of that claim of a patent, or in any subsequent proceeding for the revocation of a patent insofar as it relates to that claim. So, the certificate of validity is tied to the claim. So, if a claim is challenged and it survives, or if it is upheld, then for that claim there can be a certificate of validity. The patentee or any other person relying on the validity of claims obtains a final order of judgment in his favor, he shall be entitled to an order for full payment of full costs. So, this is what the section provides for. So, the certificate of validity, if a person gets a certificate of validity pertaining to a claim in, say, the first proceeding, and there is another challenge and he succeeds in it and he gets a certificate of validity at the end of the proceeding, when there is a further challenge to his patent, he is entitled to full costs once he succeeds in the further challenge also. The notice part comes in the proviso, provided that the costs as specified in this subsection shall not be ordered when the party disputing the validity of the claim satisfies the court that he was not aware of the grant of a certificate when he raised the dispute and withdrew forthwith such defense when he became aware of such a certificate. So, it is the responsibility of the patentee to put the third party who is disputing the validity of the claim on notice. So, the responsibility of sharing or of bringing the certificate to the notice is on the patentee. If the patentee does not discharge that responsibility, then it is a defense for the other party to say that I did not know there was a certificate of validity. The moment I came to know about it, I stopped or I withdrew the defense. So, that is a possibility or a potential defense that a third party may have against the patentee. So, 3, we will come back to subsection 3 again. This provision does not authorize or cannot be construed as authorizing the courts to pass an order of costs based on the scales that have been referred to therein. There is an obligation to pass an order if the party has put the third party on notice, if the patentee has put the third party on notice and has procured a certificate of validity in the earlier proceeding. So, the patentee is entitled to costs, but the scale of costs need not be what the patentee asks for. So, the patentee may have incurred legal expense, and as you are aware, legal expense can change from counsel to counsel. Depending on whom you engage, your legal expenses can vary. So, it is not obligatory on the courts or the appellate board to order the costs on the scale referred to, which means it need not order the costs that the patentee asks for. The patentee is entitled to costs, but it need not be what the patentee asks for.